All right. Good evening, everybody. We're going to go ahead and get started. So today we're going to talk about, let's see. Can everybody see the slides? Okay. We're going to talk about language and settlement agreements and why language is important, and most importantly, why it's important in a settlement agreement. My name is Shareef Valentine. Most of you guys know me. So I have been working on settlement agreements from either the union side, the management side, or as a mediator for at least over the last decade. Um, and we're going to talk a little bit about, how important a settlement agreement is, what should be in a settlement agreement, and why, we should be very careful and mindful of the language that we're using, in a settlement agreement, but throughout the mediation process as well. So let's get started. All right. So, our agenda, we're going to do an introduction to mediation settlement agreements, the importance of the language in mediation, and then some key components of a settlement agreement. So, mediation plays a crucial role in resolving conflicts by providing a structured and collaborative process for disputing parties to reach a mutual acceptable resolution. Unlike adversarial approaches, mediation encourages open communication, empathy, and understanding. The neutral mediator facilitates dialogue, helping parties explore their interests and find common ground. This alternate dispute resolution method empowers individuals to shape their own solutions, fostering a sense of ownership and satisfaction with the outcome. Mediation is known for its efficiency, cost effectiveness, and ability to preserve relationships, making it a valuable tool to resolve wide-ranging conflicts from interpersonal disputes to complex legal matters. Most of you come from a alternate dispute resolution background or mediation or conflict management background, so you know most of this already. So what role does language play in mediation? So it helps you maintain neutrality, right? So neutrality is a cornerstone of effective mediation. The mediator uses language that is neutral and unbiased, ensuring that the parties perceive them as impartial facilitators, right? And as you guys know, it's not just that we are impartial as the third party. It's that we don't even give the appearance that we're not, right? And so we want to be impartial, but it doesn't matter if we think we're impartial if the parties do not believe that we're impartial. Neutral language allows for a balanced process, allowing parties to trust the mediator and the mediation process. If a party does not believe that the mediator is impartial, they're not going to trust the process. And the reality is, if you go through the mediation process and you feel like your process wasn't impartial and you don't trust that mediator, there's a good chance that that individual is not going to trust any mediator, right? And so we want to make sure that we maintain that impartiality, so that we can maintain that trust. It's communication facilitation. Language enables parties to express their perspectives, concerns, and needs clearly and articulately. The mediator uses language to guide discussions to ensure that that each party has a chance to communicate and be heard. That's like, when we're using redirection and we're ensuring that the conversation is moving along, we're ensuring that appropriate language is being used in that space, so that we're creating that safe space and that safe environment. Language can also help clarify misunderstandings. Misunderstandings are common in conflicts. Language allows the mediator to identify and address miscommunications promptly. Through effective language use, the mediator can rephrase statements, ask clarifying questions, and help parties grasp each other's viewpoints, right? How many times have we been in a mediation or been in a dialogue, and you, as the mediator or as the facilitator, can see very clearly that the parties are speaking past each other? The parties may be saying a lot of the same language, they may be saying a lot of the same things, but because of the language that they're using or even the choice of words, they're not hearing each other, right? Or they're taking offense to things that you may not be taking offense to because you're not directly involved. So you're hearing what some of the issues are where they're really just talking past each other. Expressing emotions and intentions. Emotions often run high in conflict. Language allows parties to express their emotions and intentions in a constructive manner. Mediators use language to create a safe space for emotional expression and to ensure emotions are acknowledged and understood. And acknowledging those emotions and ensuring that the person that is expressing those emotions feel that they're understood goes a long way to creating trust and that safe space. It fosters empathy. Language is a tool for building empathy between parties. The mediator uses empathetic language to help parties understand each other's experiences and perspectives. By fostering empathy, language contributes to more cooperative atmospheres, promoting a collaborative approach to resolution, right? And so this is the reframing or even possibly redirecting. When we allow the parties to hear that we understand what they're saying, when we're helping them develop better language with each other, it allows for a more communicative conversation and more of a collaborative approach. They're not going to collaborate with each other if the language that they're using is so diametrically opposed to the resolution process, right? So if they're calling each other names and they're saying this and they're saying that and they're using language that is very volatile or bombastic, it doesn't mean that there's not needs within that language. It doesn't mean that there's not a story within that language, and we can help them with that language so that it does come across in a way that's more digestible without losing its intent. Negotiation and agreement drafting. The mediator employs language skills during the negotiation phase to guide parties towards a mutually acceptable agreement. In drafting settlement agreements, precise and unambiguous language is crucial to avoid future misunderstandings and ensure enforceability. In other words, if the parties don't understand what's in the agreement, how can we possibly enforce it, and or how will the parties know if they are violating the agreement, right? So cultural sensitivity. Language plays a vital role in recognizing and respecting cultural nuances. The mediator must be attuned to the cultural backgrounds of the parties and use language that is culturally sensitive. Cultural competence in language use helps build trust and promote a more inclusive mediation process. And this is this is where all words don't mean the same things to all people, right? And so you have to be very careful sometimes in the type of words that we use and the type of words that we are putting in our agreements, because if the parties don't agree that those words mean the same thing, we're going to be right back here in square one, or we're going to be discussing breach of agreement relatively shortly. How is the settlement? How important is the settlement agreement? The settlement agreement is a legally binding contract. The language used must meet the requirements for a valid contract, including offer, acceptance, consideration, legal capacity, and legality of purpose. Parties participate in mediation should have the authority to agree to legally binding settlement. And they should have a authority to agree to the topic of discussion. So you can't have two parties coming up with an agreement that somebody else is going to do, right? You can't have parties coming to an agreement for two different groups that they do not have the authority to make the decisions on. And so it's very important in the beginning of mediations that we're asking these questions. Do you have the authority to make a settlement? And it's not a bad idea to ask at the end as well, before we begin to work on the settlement agreement. I just want to make sure that we're clear that the parties that are here have the authority to make said settlement agreement and sign said settlement agreement. Because you would be surprised how many times somebody says that in the beginning, and then when they get towards the end, they say, nope, I got to talk to my boss. I can't sign this. I have to go talk to somebody somewhere else before I can sign this. I don't have the authority to do X, Y, Z. So it's always a good idea to keep asking that to ensure that you do have the right parties involved. All right. In California, the primary law that governs mediation and binds parties to mediation agreement is the California Evidence Code, specifically sections 115 through 1128. These sections outline the rules and the principles related to mediation confidentiality and the admissibility of mediation communications and legal procedures. Enforceability of mediation settlement agreements. California Code of Civil Procedure, section 664.6 allows parties to request that the court enter judgment based on a written settlement agreement reached in mediation. This section streamlines the enforcement process for mediation settlements. Additionally, if parties wish to have their settlement agreement enforceable as a court judgment, they may need to follow the procedures outlined in California Code Civil Code 664.6. This involves filing a stipulation or a motion with the court to enter judgment based on the terms of the settlement agreement. So this would apply to court-based mediation. All right, so before we get into some of the key components of a settlement agreement, are there any questions so far on anything that we covered, as far as the language, the purpose of language, and things like that? Outstanding. All right. So key components of settlement. So language shapes and molds each essential element of a settlement agreement by providing precision, clarity, and broad understanding of the terms. Well-crafted language ensures that an agreement is not only legally sound, but also conducive to successful implementation and dispute resolution. A lot of times you will find that what you say on paper or what you agree to at the table may not always be as easily implemented as it sounds. And it's very important that when you think through the processes of a settlement agreement, or you think through what language is going to go into a settlement agreement, there's also great consideration given to the implementation of that settlement agreement, right? And so I'll give you an example. If you come up with an agreement, and let's say it's a workplace dispute, and you have a supervisor that says, oh, I'll give an employee, I'll agree to give them X amount of days of PTO every pay period, right? Like, I'm just going to do that, and that'll make everything go away, and we're good to go. And so you make that settlement agreement. Nobody talks to payroll, right? Nobody talks to HR. And then you've signed this settlement agreement, and then you go to payroll and you say, hey, I got this agreement. This is what I got to do. Payroll says we have absolutely no mechanism to do that. I have no way to implement that. I mean, I know what you agreed to, but our system doesn't do that. And you say, well, we got to do it. We've already agreed to it. You got to find a way to do it. And your payroll says we have 20,000 employees. We can't create a system for one employee because you agreed to this thing, right? So now what do? Because you have your agreement, you have your language is beautiful, your agreement is beautiful, you've made the whole thing go away, but you can't implement this agreement, right? And so you have to give consideration to the things that you're saying that you're going to do. How are you going to implement those things? And it's very important that you speak to those things, and we'll talk about that in the elements. And you'll see this a lot with not just settlement agreements, collective bargaining agreements, like, union agreements, subcontracting clauses and things like that. You'll see people agree to a lot of things that cannot be implemented. And there wasn't a lot of discussion with the moving parties that would be a part of that implementation. So, for example, if you're signing a settlement agreement and it has to do with time cards, payroll, back pay, any of those things, you might want to talk to the people that are experts in those things before you put down that you're going to agree to do X, Y, Z. If you're going to agree to something that has a third party that's involved that has to be a part of that implementation or has to be a moving part of that machine, you need to talk to those parties to ensure that what you just agreed to can actually be done. So, components of a settlement agreement, introduction. Essential element is you want to clearly identify the parties involved. And what's the role that language plays in that? Language shapes this component by specifying the names and the roles of the parties to ensure accuracy and preventing ambiguity. So, for instance, if let's say you have a group of teachers and you're crafting a settlement agreement that is going to apply to a specific group of teachers, right? Is it your first grade teachers? Is it your second grade teachers? Is it all the teachers in the building? Is it the teachers in the first wing of the building? Who exactly does it apply to? So you don't want to put language that says the teachers or the employees, right? What employees are we talking about? You don't want language that just says the community members. Is it the entire community members? Is it the Oak Park community members? Is it the Black community members? Is it the Hispanic community members? What community exactly are we talking about? You want to be very specific in who you're talking to, and you also want to be very specific in who the settlement agrees to and who the parties are. Right? Because you never want to have a settlement agreement where the person that is on the other side of the table is like, oh, I'm included in that as well, because you can't tell from the agreement who's getting what and who the agreement actually applies to. You want to have a recital or a preamble. The essential element of that is to provide context and background information on the dispute. So you want to give a little bit about the dispute so there's an understanding of what this settlement agreement is about. And what the dispute that you're trying to resolve is. So there's two reasons for this. When you're done with a settlement agreement, when you're done with a dispute, you don't want to go back and rehash that dispute out. The whole purpose of the settlement is to resolve that dispute. But if you can't give an explanation of what exactly the dispute is, then either of the parties can say, I want to come back and this is a new issue. Well, it's not a new issue. We already have a settlement agreement. Well, when I look at the settlement agreement, does it say this was an issue that happened on this date, on this date, on this date? Or does it say, we're here to resolve a dispute that was in the playground? Well, I mean, that could have been 52 different disputes in the playground. How do I know it's this specific one? Right. So then you end up right back in the same place because you basically have an agreement you can't enforce. And then language in this section sets the tone and helps parties understand the history and the reasons for the agreement, promoting transparency and clarity. Now, what's important here is when you have your recital or your preamble in the agreement, both parties have to agree to what's going in that language, right? And so you want to make sure that you're using language that is neutral, that both parties can agree to, because the last thing you want is for people to not sign a settlement agreement, not because the benefit of the settlement did not benefit them, but because they don't like the language in the settlement agreement, or they feel like the language is disrespectful. You would be surprised how many people will walk away from a perfectly good settlement agreement because of choice of words. All right. Then definitions. Definitions are extraordinarily important, right? So you want to define the key terms used throughout the agreement. Clear and precise language is vital to avoid misunderstandings. Well-defined terms enhance the agreement's understanding and interpretation for consistency, right? We want to make sure we're speaking the same language and everybody understands what these words mean. If you have people that have a settlement agreement and they have no idea what is in that settlement agreement, one, it's hard to enforce. Two, it kind of feels like you were forced into the agreement. And three, you're not going to have the buy-in that you would if they actually have an understanding or feel like they were involved in the process. And 9 times out of 10, if they can't understand what's in the settlement agreement, they probably weren't all that involved in the process, right? So you want to be very careful with that. Let's see. Here, go to the next slide. So the agreement to settle. The key element here is it explicitly states that the party's intention to settle the dispute. Language's roles here. The language should convey a mutual understanding and commitment to resolving the conflict, fostering a positive and cooperative atmosphere. And so you want language in there that says that the parties do agree to settle this agreement, right? Like it seems like a no-brainer, but you would be surprised how many settlement agreements you might see that don't actually have that language in there. Terms of the settlement agreement clearly outline the specific terms and conditions agreed upon by the parties. The language shapes this section by articulating each party's responsibilities, rights, and obligations. It must detail unambiguously and easily comprehensible. So if you are a party in this agreement, you need to understand what your role is in that agreement. So if there's a breach of an agreement, there should be no way people can wiggle out by saying, oh, I wasn't sure that it was my responsibility to contact payroll and tell payroll that you were supposed to get this additional PTO. I didn't know that. It should say that in the agreement, right? What are the roles? When should this person do what, right? Like, so within 30 days of this agreement, HR's responsibility is to contact payroll and do X, Y, Z, et cetera. Everybody should know exactly what they're responsible for when that agreement is signed. Release of waivers. This specifies that parties release each other from any claims arising from the dispute. The language ensures that the breadth and limitations of the release preventing future disputes. It must be carefully crafted to cover all relevant claims without unintended consequences. Now, this is very important that this language is very specific and it's very clear, because in this case, people may be giving up their right to something, right? So whether this is their right to a complaint, whether this is their right to a dispute, you want to ensure that they understand that that's what they're giving up, right? So let's say you're doing a settlement agreement for an EEO complaint, right? And you have an employee that is saying, you know, I want XYZ amount of whatever. And you're going back and forth and you're negotiating down, and what they originally asked for is not what they're going to end up getting. So we've ended up at a smaller amount and we've ended up with lesser things that they're going to receive. And in getting those lesser things, that employee may not understand by getting this amount, even because it's far lesser than what they asked for, that by getting that lesser amount, it still means that this agreement means they are giving up their right to complain. So they can't go back and file this complaint. Do they understand that they're giving up that right? You want to make sure that that is clear, right? You want to make sure that that is unambiguous and that they understand what they are giving up. Confidentiality, you want to address confidentiality of the settlement terms and discussions. You want to, the language needs to be clear. It states the confidentiality obligations using language that safeguards sensitivity and pertinent information. This helps maintain trust between all parties and ensures that parties feel secure in sharing information during the mediation process. Now, with that being said, depending on what sector you're in, depending on what state you're in, there may be some things that you can't make confidential, right? Like, so like sexual harassment complaints, depending on what sector you're in, depending on where you work, depending on what state you're in, you may not be able to get a confidential settlement agreement around sexual harassment. You may not be able to get a non-disclosure agreement around sexual harassment. So you need to make sure that you understand what the confidentiality rules are with what you're dealing with. The other thing is that sometimes people come to the table to settle specifically because the settlement process is confidential, and they're willing to pay exactly what they would pay in court. But the difference is, if they pay in a settlement agreement, they have access to that confidentiality that they would not have in court, right? And so if you breach that confidentiality, that may be the only thing that one of the parties or the other was looking for in this agreement, right? Okay. Consideration and compensation. Specify any monetary or non-monetary considerations exchanged as part of the settlement. The language shapes this section by detailing the nature and amount of consideration, avoid ambiguity, and ensure both parties are in agreement with the terms. So in short, this is the what you're getting section. What are you getting? Do you know what you're getting, right? And it needs to be very clear, because there's nothing worse than when two parties walk away from the table and they have two entirely different impressions of what the parties are getting, right? So if it's money, it needs to be very detailed. If it's going to be paid in certain amounts, you don't want to walk away from the table and say, all right, well, party B is entitled to $5,000 in $5,000 in 5 payments. Now, I can break $5,000 into 5 payments a whole lot of different ways, right? I can give you $10 the first payment. I can give you $20 the second payment. I can give you $30 the fourth payment. And then on the 5th payment, I can pay you 2 years later and pay you the remaining balance, right? Now, if that's not specified, there's not a whole lot you can do about it, but I guarantee you the other party is going to be very angry about that outcome. So if you're saying $5,000 in 5 payments, it needs to be very specific. How are those payments going to be made? When are those payments going to be made? What are the amounts of those payments when they are made, right? And so, for example, if you say we're going to pay in $5,000 XYZ, when is the start of that initial payment? Is it 30 days from the execution of the agreement? Is it 90 days from the execution of the agreement? Is it 2 years from the execution of the agreement? If you walk away from the table and you don't specify that, I'm never going to be in breach of an agreement until I hit whatever date it is that I put on the agreement. And if the date is nothing, it's infinity. The agreement says that I have to make 5 payments to equal $5,000. It doesn't say when I have to make the payment, so I'm getting there. Like, I haven't received my money. I'm getting there. You'll get it. You'll get it. You can't prove that I haven't paid it yet. What day was I supposed to pay it by? When am I late? Right? So you want all of that to be clarified in the agreement. Governing laws and jurisdiction. Indicate the laws governing the agreement and the jurisdiction where the dispute will be resolved. Clearly define the applicable laws and jurisdictions to provide a legal framework. Language precision is essential to avoid conflicts related to interpretation of these clauses. Now, this will also depend what sector you're working in. So like, for instance, if you're working in the EEO realm, if you're working in family law, there may be certain things based on those laws you can't make settlement agreements on, and you want to make sure that you're clear on that, right? Like, and a settlement agreement cannot violate for example, if it's employment law, settlement agreements can't violate employment statutes, right? Like, an employee cannot sign a settlement agreement to do something to themselves that the law has protected them from. Right. So you can't put those into settlement agreements, depending on, again, what state and what jurisdiction you're in, or what discipline you're writing a settlement agreement for. Right. It will depend on what you can actually do and what laws govern that. So, like, if it's a collective bargaining agreement, or if it's a settlement agreement for to delay a strike or put off a strike, there's a lot of range and latitude that you have. But if it's a Title VII discrimination complaint, then you're limited, right? You're limited by the statute on what you can settle and how you can settle. And then signature and execution. Include spaces for signatures and date of execution. Language finalize the agreement is to clarify. It's crucially establishing the parties' formal consent. The language should express the parties' intent to be bound by those terms. You want people's signature on the agreement to matter, right? Like, if that person is signing an agreement, they, i.e., don't have the authority to sign the agreement, they're not the appropriate person to sign the agreement. So for example, you're making an agreement between a municipality, like a city, and the community, right? And at the table is the mayor or secretary, who has no authority to do anything, is saying, well, I'm going to sign the agreement and XYZ. And then the agreement is not enforced. And they say, well, the agreement is not going to be enforced until the mayor signs it. All right, well, then the secretary's signature doesn't need to be on this agreement. They have no authority here. Then you need to make sure you have the right authority on the signature block, or we're going to be here all day, right? So you want to be careful and make sure that you have the appropriate people on the signature block, and or in some cases, you may have multiple parties that have not agreed to have one representative. So sometimes this happens. It may happen with community organizers. It may happen with unions. It may happen in consorted activities with, employees or different things like that, where you may have one group of employees that says, I agree to let Susan represent all of us. And then you have two employees that say, Susan don't speak for me, right? So if Susan speaks for a group, Susan can sign for that group. But the two individuals that said Susan doesn't speak for me, their signatures individually need to be on that settlement agreement, because they do not have an agreement, nor do they have jurisdiction to make that agreement on behalf of those employees, right? Or whoever that group may be. All right. So some tips for mutual understanding in language. So clarity and precision. You want to be clear and precise with language that helps to articulate thoughts and ideas without ambiguity. Parties can comprehend each other's positions more easily when the language used is straightforward, right? Sometimes we have a tendency to beat around the bush in the mediation process, but when we get to the settlement agreement, we need to get brass tacks, straight to the point, right? We need to be straightforward in what exactly are we saying needs to be done, right? And then ambiguous and vague language may lead to misunderstandings, making it essential to use words that convey specific meanings. The other thing about vague language, and sometimes you'll see, depending on, what kind of agreements that you're making, sometimes you'll see this with contract language, where parties can't agree on a certain thing and they'll purposely leave the language vague and then let the parties hash it out in a separate setting, right? So like you may see this in labor agreements, you may see this in, large contracts between like a contractor and a government or what have you. But in a mediation process or an ADR process, we don't want them to go back to the table and hash it out for specific parts of the agreement. We want them to specifically understand what that language says, so they don't have to go back and forth arguing, going to arbitration, going back to court for breach of agreement because it was specifically left vague. Now, however, you will have parties that do want to leave language vague because they have all the plans in the world to get out of that agreement, right? And so you need to be mindful that the language that is in the agreement is understood by all parties to not only be binding, but they understand exactly what it's saying and that there's an agreement on what the language is saying. You want to actively listen and use reflective language. Mediators using active listening skills to understand parties' perspectives, and they employ reflective language to confirm their understanding. So you're doing this throughout the mediation process. You're reflecting language back to them to make sure that you have and you understand, what they're trying to say. We need to be doing the same thing as we're going through the settlement agreement. As we're drafting the language for the settlement agreement, you want to make sure you understand what they're asking you to put into this agreement, or what they're asking to be placed in the agreement. Because here, at the end of the day, and this is America, and in our culture, titles matter. And so you're the mediator, and people see you as the subject matter expert. So if we're proffering language, people may say, oh, looks good, you must know what you're talking about, and they're just going to go with it and defer to you. So you want to be very careful about that. that they understand what is going into their agreement, right? And that you understand what they're saying that they're agreeing to. And you want to use active listening and reflective language. By repeating and summarizing what each party says, the mediator ensures that both sides feel heard and understood. This process helps clarify any potential misrepresentations and builds trust. You want to use empathetic language. Mediators use empathetic language to acknowledge and validate the emotions and expressions by the parties. When parties feel their emotions are recognized and understood, it creates an environment conducive to open communication. Empathetic language fosters a sense of shared understanding, making it easier for parties to find common ground. Now, if the temperature at the table is still hot by the time you get to the agreement phase, so you're trying to sign the settlement agreement, they're still hot, emotions are still running high, it is going to be very difficult for you to get them to agree to language. And language always matters, but most especially language matters when people's emotions are running high, because it could be one word or another that triggers people to be adversarial to a specific section of an agreement, right? So let me think of an example. If you're writing up a settlement agreement and it says a party shall be forced to do XYZ, right? And it may be something that the party already agreed to. The minute that they see the word forced, no, I'm not agreeing to that. Nobody's forcing me to do nothing. Well, the reality is, yeah, we are. If you sign this agreement, it's enforceable, right? But does that language need to be there? No, right? It's adversarial language. It's not that. And the other thing is, you have some parties that want fault to be put in a settlement agreement. Some parties may be okay with that. Some parties may be okay with admitting, I'm doing this settlement agreement because XYZ, blah, 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 blah. And you have other parties that will not sign a settlement agreement that assigns fault to them, right? And then they'll tell you, if you're going to assign fault to me, we might as well go to court, right? There's no point of me coming through the settlement process if I'm going to be found at fault, right? And there may be justifiable reasons. Maybe they have other liabilities that they're concerned about and they don't want to be found at fault. But language that points the fault at them is going to lead to them walking away from a settlement agreement. So you have to find a way to find neutral language, right? And then you want to questioning techniques. Mediators use carefully crafted questions to elicit more information and encourage parties to express themselves. Understanding thoughtful questions help uncover underlying issues, motivations, and concerns. This exploration, guided by language, promotes a deeper understanding of the root causes of the conflict. So you want to make sure, and we always use the iceberg picture, right? Because what people tell you they're at the mediation for, what they have come to the mediation for, I mean, that's only the beginning. It's always more. There's always more than why they're saying they're here. And you begin to see that, and you begin to feel that. And here's the thing. If we get to a settlement agreement and we've only addressed the tip of the iceberg, we're going to end up right back here because there is so much more in this conflict that has not been addressed. And so as a mediator, you want to try to flesh that out as much as we can, get them to communicate, get them to feel safe enough to bring all of that out. Because if we can resolve as much of this conflict as we can and get that into a settlement agreement, the more the better. Because in most cases, when you're dealing with mediation, especially non-court mandated mediation, but even sometimes in court mandated mediation, these people are going to see each other again. Right. And so if we have a partial resolution and we send folks back and they have to go work in their cubicles across from each other, or they have to go work in the community together, or you have two business owners that live right next door to each other, or neighbors or what have you, and those things are unresolved, we're going to end up right back in the same situation. And we want to make sure that we understand what is the totality of the issue. Okay, avoidance of jargon. Mediators use plain language and accessible language, avoid legal or technical jargon that may confuse parties. Using language that is easily understood by all parties ensures that everyone can actively participate in the conversation. It prevents misunderstandings arising from misinterpretation of complex terms. You want to make sure that we're dealing with an agreement that the parties actually understand. So we want to make sure that we're using plain language and is straight to the point, right? A lot of times, especially in the HR world or even in the court system and things like that, we have a tendency to use our own boilerplate language, right? We have a tendency to use language that is the same type of language that we use every day. But the parties that we're working with may not always understand what that language means. And so again, if you understand completely and perfectly what the settlement agreement says, and one party understands completely and perfectly what the settlement agreement says, but another party has no idea what any of those terms are, we're going to have problems, right? And I may not have the problem as the mediator because I'm going to walk away and I'm going to go on and I'm going to move on to the next mediation. But those parties are going to have a problem either enforcing the agreement or with the relationship if they feel like what they understood to be agreed upon is not actually what they agreed upon. Cultural sensitivity. Mediators must be culturally sensitive in their language use, recognizing and respecting diverse backgrounds. Cultural nuances can impact communication styles and interpretations. By using language that is respectful, respects cultural differences, mediators contribute to more inclusive and understanding atmospheres. What also goes along with this is you may be dealing with people that may need translators. You may be dealing with people that have learning disabilities. You may be dealing with people who have issues with reading, whether it's being able to read, write, and comprehend in itself, or people like myself who have dyslexia may need a little bit more time and things like that. You need to be aware of those things, right? Because if you're not closing the gap in those barriers of communication, then that person is not, in fact, being provided with a safe space to get to an agreement that is beneficial for all parties, right? And so you want to make sure that you're being mindful of that as well. So if you have somebody that is having a difficulty understanding what's in the agreement, a difficulty understanding what is being said, then we should find ways around those barriers before we sign any agreements. And then again, you want to use neutral language, maintain neutrality by using language that doesn't favor any party. You want to use neutral language that prevents defensive reactions and fosters an environment where parties feel they can express themselves without judgment. This contributes to a more open and constructive dialogue. Language serves as a bridge for mutual understanding and mediation. Through clear and empathetic and culturally sensitive language, mediators create an atmosphere where parties can express themselves, be heard, and ultimately comprehend each other's perspectives, facilitating the path to resolution. The path to resolution does also matter, right? If we just jump straight to the end because party A wants their money and party B is willing to give up the money, and we haven't resolved any of the other issues, then you still haven't addressed the core issues or the relationship, right? And getting to an agreement that has completely ruined and fractured the relationship is still also problematic, right? And so we don't want to push the parties, right? Because the mediation process is their process. We're not just rushing them to get the agreement because we're trying to knock out 5 agreements in a day, and we want to have, we're all about our settlement track record, right? Getting an agreement and shattering a relationship is not a good thing, right? And so we want to be cognitive of that because the journey is just as important as the resolution. We should as mediators, we should not cause any additional harm. And some tips around barriers. So plain language, choose simple and clear language, avoid jargon and complexity, written summaries, supplemental verbal communication with written summaries, provide visual aids for reinforcement. So for example, if you're doing a settlement that includes the community, or you're working on a settlement agreement or a collective bargaining agreement, like you're working with a union or employees or what have you, sometimes presenting a presentation on how things are going to roll out is helpful. Some people need visual presentation, right? Like slapping up a slide with a whole bunch of numbers on a spreadsheet is not beneficial to everybody. Some people need to see visually how those numbers affect them or impact them before they feel comfortable agreeing to anything, right? So, visual diagrams, use visuals like charts and diagrams to aid understanding. Visual transcends language barriers. Translators and interpreters, we talked about that. Encourage questions, create open environment for questions, promptly address doubts and concerns. Break information into steps, present information in a step-by-step manner. Confirm understanding before moving forward. If you have to go through the agreement in every single section with an individual so that they understand what is being written, or you have to go through it with the parties and do one piece at a time so that the parties understand what each piece says, then do so. Provide additional time, recognize the need for extra time to process information, allow pauses and breaks as needed. Multilingual materials, offer settlement materials in multiple languages, accommodate linguistic diversity, cultural sensitivity, train mediators and staff in cultural sensitivity, and be aware of cultural nuances. Involve supportive professionals, engage experts in education or language-related fields, allow parties to bring trusted support for assistance. So a lot of times you'll have people that have language barriers or language or learning disabilities or what have you. They may want to bring a family member to help them understand and translate or read something back to them, or have them read it and then explain it to them in a way that makes sense to them because they know how to best communicate with that individual. That's okay. But again, like in all mediations, you want to make sure that all parties are okay with that individual engaging in the mediation process as well. And in many cases, this is what people bring lawyers for. They don't want to read the settlement agreement. They don't trust anything that anybody else is going to do. They want their lawyer to read over it and say, "Hey, this is good. This, if it's good to go, then they'll sign it." Right. So it takes those various forms, but you don't only have to have a lawyer to come to a mediation with you to help you feel comfortable with a settlement agreement, right? It could be anybody. In some cases, it's a union rep. Some cases, it's your spouse. Some cases, I've seen a lot of cases where people bring their children to help either translate or read or make sure that they appropriately understand the language in the agreement, and also understanding that an agreement seems simple when you get to the agreement based on words. We agreed to a thing. I agreed that I'm going to drop my case and you guys are going to give me, the 4 days back that you took away from me for the suspension that I got, right? So I got a 4-day suspension and we overturned it. That seems super simple. And then they get the settlement agreement. It's 4 pages long. And they're like, what is all of this? What is all this? And I'm waiving. What am I waiving? Right. It can be overwhelming. And there's a reason for all of those things to be in the settlement agreement. They all have their place and they all have a legitimate reason. But it may take to walk through all of those reasons with that individual, and they may take some time to read all of that for them to feel comfortable. Because if you came up to me with a 7-page settlement agreement for five sentences worth of words that we agreed to, no, I'm not signing that in 15 minutes. Right. And if I've never seen a settlement agreement, I've never been through a settlement process, that may be very intimidating for somebody. And then just some best practice reminders for clarity and concise, using straightforward language and avoiding unnecessary complexity. And sometimes you'll see this, whether people are lawyers or not lawyers. You have people that think that the more complicated you make a thing look makes you seem more lawyer-like, right? Like that's not helping anybody, right? And law and order that's not real. Like none of that stuff happens, right? Like half the things you see in courtroom and TV, or half the things you see lawyers do on TV, is not a thing. Like there's no thing where Stabler is sitting at the back of the courtroom and they're holding like the little folder, and the judge is like, "Come on up," and they come up and they're like, "Oh, let me give you this evidence," and boom, case is won. We won our case because we got none of that happens. Like that's not a thing. Discovery would make sure that would never happen, because there aren't that level of surprises in a courtroom unless somebody says something outrageous on the stand during cross-examination or recross or anything like that. So we want people to get all of that out of their head. When you're doing a settlement agreement, you want to make sure that people understand what is being said. So avoid the complexity. Active listening. You want to repeat and summarize and show understanding. Use reflective language to confirm perspectives. You want to have neutrality, maintain a neutral tone, avoid language favoring any parties. Empathy, acknowledging and validating emotions, creating a supportive atmosphere. Cultural sensitivities, respect diverse communication styles, use inclusive language. Open-ended questions, encourage in-depth discussion, and explore underlying issues. You want to avoid assumptions, clarify information, prevent misunderstandings. Positive, solution-oriented language. Frame discussions positively, focus on solutions and the future. Provide clarification, clarify terms and concepts, allow questions for clarification, and clearly defined agreements. Draft specific, unambiguous agreements, define terms and responsibilities clearly. And done. So I'll say just in the outset, This is boring. It is. This is probably the most boring part of mediation, but it's also one of the most important parts, right? It is very, very important because at the end of the day, 4, 5, 6 years from now, 6 months from now, 9 months from now, you may not remember a single thing that happened in that mediation. But what you will have is that agreement. And that is the only thing that is going to matter after this mediation is done, is what's in that agreement. And so you can say after you get the agreement, but we said this and we said this and we were going to do this and we were going to agree to that, blah, 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 blah. Doesn't matter. What matters is what's in that agreement, right? And you may have an agreement that is 20 some odd years old. And somebody might, I was at work the other day and somebody whipped out an agreement that was written on a typewriter. And literally typed on a typewriter. It was typed on a typewriter and photocopied with an old Xerox photocopier. So we're literally looking at a black and white photo of a typewritten letter. Old, right? And so there were people that were saying, well, that's so long ago and blah, blah. I don't care how long it was ago. Is that your signature? Yep, that's your signature. Is that your signature? Yep, that's your signature. That is y'all's agreement. And unless you guys have renegotiated another agreement that supersedes this agreement, that agreement is still in place. And you both have to honor said agreement. Sorry, right? And so if that agreement is ambiguous or it's vague or it's creating problems or what have you, that is what they have to live for. That is what they have to live with. So it's very important that after we're done and the mediation is over, because the mediation, that's all the active stuff. That's the moving parts, right? For us as mediators and ADR practitioners, that's the fun part, right? But the settlement agreement is just as important because that is ultimately what they have agreed to and what they're going to walk away. And those words on that paper is what they have to live for that issue and for them and that relationship going forward. Any questions?
Can you forward this PowerPoint out?
Sure.
That'd be wonderful. Thank you, Shareef.
Tyler.
Yeah, thank you. Thanks for this. This is kind of my first viewing or just introduction to agreements, and it seems clear that a lot of legal knowledge is required to get this right and to make it legally tight. As a non-lawyer mediator, how do you go about that? I mean, it seems either important to have a lawyer present for drafting the mediation or spend, a decent amount of time educating yourself on, all the relevant laws to draft the agreement. So I guess, how do you approach that for a non-lawyer mediator?
Yeah, so I'll say this. Well, let me say it the other way. I know lawyer mediators that don't get this right. So, I think it starts with understanding the industry that you're working in, right? And I think that's a responsibility of all of us. So if you're in HR, you should be, whether you're a lawyer or not, you should be an expert in the laws that are within your jurisdiction, right? If you're working in the courts, then you have people to give you that advice. If you're working within an organization, if you're a mediator within a company or a government entity, you should have, general counsel or somebody like that can review your agreements. I'm the director of a large labor relations department, and I still have my general counsel review all of my agreements, and I've been doing this for years, right? And I even have some of my staff review some of my agreements just because I want another set of eyes on it, just in general. But you want to make sure that you're dressed with whatever laws that you're working with in whatever jurisdiction that you're working with. Sometimes that may take a lot of research, right? But it really depends on what the agreement is and what you're agreeing to, right? Some things don't really require law. If you're just agreeing to not cut your neighbor's grass anymore when you cut your grass, right? There's not necessarily a lot of laws that you need to engage with that. But if you're agreeing to, for instance, waive 4 years of back pay, yeah, you may want to know if there is a law out there that says that you can't waive, all of those years of back pay, right? You can't give that up in exchange for a thing. Spoiler alert, yes, there is a law that says you can't do that, right? And so it really is going to be dependent on the industry that you're in, but you're going to have to, it's one of those things that you have to educate yourself on. But if you do have access, through like Rachel, you work for a city, correct? A government entity?
Yeah, I'm contracted with DC.
Right. So you're
Superior Court.
contracted with DC. So you guys normally have somebody who can review settlement agreements if you needed them to, correct?
Yeah, so I just sent an agreement out this morning at 1 a.m.
Yep.
And
So
it's still
and over the years, as you begin to do that, even if you're not like you're not up on it like every single day when you first get started, you'll learn. And your general counsels, your inside counsels, even people that are giving you legal advice, they when they see stuff that's like, oh no, they make sure that you understand exactly why we can't do that and whatnot. And I always say that as you're in those industries, it's incumbent upon you to take those notes and learn those things as you are reviewing, and you'll see that as you get more experience, you'll need less edits and less kickbacks and less advice from your counsel as you begin to submit them. But I mean, I've been doing this for years and I still submit all myself, even when they're like, I don't need to look at that. Yeah, you're gonna look at it. I want another set of eyes on it.
And when you say submit that to legal counsel, do you mean like a signed and authorized agreement and then you send it off?
No.
Okay,
we
before.
submit so it and it depends, right? It depends on what industry you're in. So like if it's me, I'm the HR entity, and so if I submit an agreement, I'm submitting an agreement before I sign anything. To make sure that what I'm agreeing to on behalf of my organization, I actually have the authority and that the organization is willing to enter into that agreement. So as a mediator, you may see like organizations may have a limit. So you may have an organization that says for $5,000 or below, I don't need to see anything. For $10,000, I don't need to see anything. When it gets to $50,000, it needs to go to this person, needs to go to this person, needs to go to this person, right? And same thing with certain government entities, even as a mediator. If you're mediating a case that equals up to, let's say, $100,000 or what have you, there may be a higher level of review. And so each organization will have protocols for those different things and whatnot. Now, it's a little bit different if you're a private mediator and you're running your own firm and things like that. You kind of have to, make your own way for your own legal advice. I mean, it's almost a operate at your own peril type of deal. You want to make sure that you do have some semblance or some way to get that legal advice when you do need it.
Got it. Thanks.
Anya, did I say that right?
Yeah. Hi, Shareef. Hi, everyone. So my question is kind of following up on Tyler's, and it's kind of a simple question, but I'm curious about the binding part and the enforcement of it. So by binding, do we just mean you're bound by law and that document would hold up in court? Or is there some kind of enforcement mechanism built into the contract as well?
So, well, yes and no, but it also depends on what state you're in. Right. So like in the slide deck, is language where it is in the California statute. But each state is going to have statutory language around settlement agreements.
Okay. So the parties, when they sign it, they agree to those terms and to act on that. Okay.
That's right.
And then if there's some situation where a party isn't abiding by that agreement, it could just potentially go to court.
Yeah, it could go to court, or in some agreements there's language that it can go to arbitration where you select an arbitrator to make the decision, maybe even go to court, or depending on, again, it depends on the industry and it depends on the mechanism that you choose for enforcement in the settlement agreement.
Okay.
So like, for instance, if you work for a government entity and you file an EEO complaint, you have an EEO settlement agreement, right? Like,
what's EEO?
Equal employment opportunity. So like the EEOC is the Equal Employment Opportunity Commission. And so they govern, discrimination in the workplace for vast numbers of industries, right? And so if you file a discrimination complaint against your organization and then you go through the process and then you guys have a settlement agreement, you decide to do away with your case. A lot of those settlement agreements will say that if the agency violates the settlement agreement, the case goes straight to court. Right. And it picks up right where it left off. right? And so one, now you're going to go to court, and you're going to go to court having already identified that you're in violation of a settlement agreement. So your credibility is not going to be great already, right? And then you've lost a lot of time on your clock. And, you know, a good representative could say, well, my case has been prejudiced by how long it's now going to take us to get to court. We're going to go to court. Now it's going to be 2 years later because we had a settlement agreement. They were just buying time. They were wasting our time. They had never had any intentions of following this agreement. All they were doing, this was a delay tactic. Now we're 2 years down the road, and my client can't actually testify to what happened because it happened so long ago. Had we had gone straight to court, we would have had a better chance in court, blase, blah, 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 right? Most people do not want that level of liability, right? And so, you know, that so depending on the agreement, that's how you that's the level of enforcement that there is, right? If there's a breach of an agreement. So it's important that it's clear what happens if the agreement is breached, right? Do we just sit out in the front yard and argue about it? Like, so we're just going to shout back and forth and say, no, I disagree. You broke the agreement. I broke the agreement. Or are we going to go to an arbitrator and let an arbitrator decide who violated the agreement, who breached the agreement? Are we going to go back to small claims court, right? Are we going to go back through the court process? All of that needs to be clear in the enforcement of the agreement, because it's a lot like the grievance process in employment, right? Between the union and the employer, the grievance process at the end has binding arbitration, because if there is no binding arbitration, then there's no point of having a collective bargaining agreement.
Okay, gotcha. And so then in civil mediation, is there any chance that the parties would just go back to the mediator, or does it usually escalate?
Well, it depends on the agreement, and it depends on the mediator. And same thing even with arbitration. Sometimes you get an arbitration and agreement, and the arbitrator may say, all right, well, you win your case, but you won your argument. But in order for us to determine what the damages are, you have to go back and do all of this research, blah, 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 blah. And so the arbitrator may retain that case for damages, or they may say you need to retain another arbitrator to make a determination on the damages, right?
Okay.
And so the parties may agree to go back to that mediator. The parties may agree to go to an arbitrator. It really depends on what the parties agreed to. Or if the mediator is open to that. Some mediators may say, oh, man, listen, it took us enough to get y'all here. God bless you. Y'all have it. Y'all are great. But if y'all breach this agreement, you need to find somebody else, right? It really depends on what the parties agree to. And then the parties may say, you know, yes, this mediator got us to the finish line, but we don't want to see him no more either. Right. And so they may not want to agree to go back to the same mediator to hash out a dispute with the agreement. It really it depends what ends up being the agreement, because ultimately the agreement is their agreement.
Mm-hmm. Okay, thanks.
Any other questions? And also, as you guys all you guys know how to get in contact with me. So if you think of any questions that you have in the interim or afterwards, you guys always feel free to email me or reach out to Professor V, and she'll get the information to me, or reach out to anybody in Peace and Education, and they'll get the question to me, and I'll respond. All right. Well, you guys survived some of the driest education material on earth about mediation. And it was an absolute pleasure to present and speak to you guys tonight. And I hope. Go ahead, Rachel.
No, before you leave, I just wanted to say that you did an excellent job in kind of clarifying, and I like the questions that were answered from Anya and for Tyler, because it's really important when we're doing these contracts that we don't know everything. Like you said, you don't have to be a lawyer. The lawyer messes up, and I think that was really important to share that, because even if you're in a new area like myself, I'm from LA, and so I just did a contract the other night. And they kept talking about Fort Totten, like, we're gonna meet at Fort Totten. I'm like, what is that? And so ask, like, hey, what is that? Like, just Anya asked, like, what is that? You know, it was very helpful. Basically, it was just an area in DC. And I thought they meant like I thought it was pertaining to like an elementary school they were trying to meet to get, you know, but it was just an area, a location that is called. So in this field, we're always learning and we're always growing, and there's nothing that we always know. And so I just like how you made sure that you said, hey, even attorneys, this and that, because sometimes people can have, they probably feel like lack of confidence because they may feel like they need this, they need that. But the best advice, like you said, is ask questions as you're in there. So I really appreciate you elaborating on and expanding on that, because it's very important for people to feel that it's okay to be where you are as long as you're willing to learn.
Couldn't have said it better. All right, you guys have a great night.